IP, it has a lot of advantages. You're more likely to grow. If your business is 21% more likely to grow based on the study conducted by the European Patent Office and the EUIPO, you're 21% more likely to grow. SMEs with at least one registered IP right are 21% more likely to experience a growth period, and also 10% more likely to develop into high growth firms. Filing at least one patent increases the chance of high growth by 9%, while filing at least one trademark raises it by 13%. So these are all statistics to show the advantage of protecting your intellectual property that we had addressed in the previous slides. Another slide, please. Okay. Now, how do you identify your hidden IP? The first step of taking advantage of your IP is knowing what exactly is the IP that I have. You can do this by an IP audit. So an IP audit is a review of the assets that your businesses own, the business owns, uses, or may be entitled to. So through an audit, you can identify existing and potential IP assets. So you look into your business. You then identify, okay, what, based on everything that has been said and will be said in the course of this conversation, what are the things that I have already that are my existing IP assets? What other things do I have, or can I generate, or can I create that can be a potential IP asset? Again, you then look at, okay, what have I protected? What do I have registration for? What do I need to get registration for? Who owns the key IP that I have? Is it the person that the person I commissioned to do the work? Who actually owns the IP I have? I have invented this product. Or is it my staff that has the IP in this? You confirm who actually has legal ownership of that IP. Then you then uncover things in your business that are underutilized, right? And you say, okay, well, for this particular IP, I don't use it, but I can monetize it. Okay, so that is another way that that's another benefit of an IP audit. Then again, you can then identify, oh, wow, this particular IP that I'm using belongs to somebody else. So what do I need to do, right? Do I need to get relevant authorization? Do I need to stop using it? You can also then recognize third-party IP that you are using without authorization. So can I see the next slide, please? Then what do we do? The same protection. How do you protect? First, register your rights. Your business name, your logo, your product names, register your IP. 2, secure ownership early. Secure ownership early. Never assume you automatically own what others create for your business. Ensure you have written agreements. If you commission someone to do work for you, ensure they've signed it. Your employees, ensure that they've assigned their rights to it. Contractors, designers, developers, ensure that they have assigned, ensure that the ownership and protection of your intellectual property belongs to your company. If you are going to get, you're going to make presentations that have to do with your IP, always ensure that you have non-disclosure agreements, internal policies. So this is, I can't overemphasize this point, the fact that you must have these internal controls. You must have NDA agreements when you are maybe going to make a business pitch with people. Protect your IP through non-disclosure agreements. And then watch the market for misuse of your IP. I had mentioned the fact that IP could become generic. There's so many names that in certain jurisdictions have become so generic that even the owners cannot lay claim to it. So you have to be very conscious of the marketplace. Most times people engage law firms to do watch services, which is they help them go to the market, brand monitoring. They go to the market, find out is somebody using my product. Most big companies do have that, but for an SME, it's okay to check the trademark journals that may have come out. Just be conscious of it. We go out every day, right? Be conscious that you're not using someone's IP. Be conscious when you go out that someone else is not using your IP. So monitor your IP. If you find out somebody is using it, enforce it. You file an action. You send a cease and desist letter. You do all that you can right, to prevent of the misuse of your intellectual property. Let's go to the next slide. Now, can you commercialize it? I mentioned this in passing. You can assign it. That's when you sell the property, the intellectual property, for you transfer ownership of the rights. Again, you can license. I've mentioned licensing. That is when you give the intellectual property to someone to use for a period of time and with certain restrictions or otherwise that you may have. Again, you can franchise. We've seen a lot of companies that we see are actually franchised arrangements. So you can also franchise it. So what happens is that somebody will use your product, your name, your name of your service, and then you would, to a certain extent, say you must actually comply with the brand, the quality, the outlook. So they always have conditions for which you can belong to a franchise arrangement. So those are different ways in which businesses, you make money whilst you're sleeping, technically, because you are not doing so much, but your brand is making money for you. So this also emphasizes the benefits of intellectual property protection and commercialization. Please, next slide. Thank you. So in closing, protecting your intellectual property is not just a legal formality. It's a strategic investment in the future of your business. When you hold strategy sessions at the beginning of each business year, include an evaluation of your IP and its impact on your business. As a business owner, your ideas, branding, and innovations are central to your competitive edge. Always be aware of this. By taking a proactive approach to identifying, securing, promoting, protecting, and enforcing your IP rights, you position your business for long-term value, resilience, and growth. Be focused, be vigilant, be agile, make protection a priority, not a reaction. Thank you. I think that's the end of the slide.
Yes, it is. It is. Thank you so much for that. That was really, really nice. I can see a lot of claps from the chat section. Thank you so much, Chinwe, for that. That was very in-depth. I personally didn't know anything, to be honest, about patents, trademarks, and copyrights. It's not my docket, but I'm happy you've taken us through this, and I'm happy you made time to, represent Madam Ua, and we're really, really happy for the presentation and the collaboration. Thank you so much. So maybe if you can respond to, I can just see one question in the chat section. Maybe if you can respond to that before we move on. So Gertrude is asking, how do you assess your IP assets?
Okay, so like I said, you do an IP audit, right? I mentioned that in the presentation, and that is when you settle down and then you look internally to say, okay, what are the assets that I have? What are the trademarks? What are the trademarks? What are the patents that I have? Existing patents, existing copyrights that I may have, right? And then in terms of, if you are talking about value, what value do they have? That's a total ballgame. We have IP valuation experts that can actually settle down and look into your IP and say, what is the value of what you have? But first of all, the first step is identifying what intellectual property you have, right? When you identify it, then you can then move on to what is the value of this IP that I have. So like I said, you do an IP audit. If you want to assess it, you first do an IP audit to first determine what it is. And then you can now move to a broader and more harder because it's not really something that you can do. You might think your IP has value, but it doesn't, right? The first form of value you can put on your IP is first protecting it. Okay, if it's a generic, let me put it in layman's terms. If it's a generic name, you've not used it extensively, you don't have protection you don't really have much protection on it, it doesn't really have a lot of value, right? So a lot of value comes from you're protecting it, you're using it, and it's relevance in the marketplace. So it's a larger conversation to say what is the value, but like the first step as a business owner, identify what IP do you actually have in your portfolio. So
Awesome. Thank you so much for that, Chinwe. Please, let's give her a round of applause. We can use the emoji button, give her a love heart, a thank you, a high five, and they're coming up because that was really, really good. I mean, we would have to pay, the such information you'd have to pay to access them or get a consultant. But we're here getting the information for free, and we're really grateful. So now, we'll just take a short break, like a 5-minute break. And I want to see if we've basically understood what Chinwe talked about, because she did take her time to go through all that. So I want us to see if we got one, two, or many things, right? From the chat, from her presentation. So I have a few questions for you. And this is something I didn't mention when we were starting the webinar. There are free gifts that will be given out, free services, right, for your businesses that will be given out, but only to the first people who give me the correct answers. Remember, we have ImpactHER staff on the call, so they will be in the chat section, seeing who gives the correct response, all right? So okay, all right. So I'll just start with warm-up questions to see if we get the gist. So the first question, this is just warming up. Before you even start a race, you have to warm up. Now, the first question, what is one creative idea, product, or piece of content you have come up with that you think might be worth protecting? What is one creative idea, product, or piece of content you have come up with that you think might be worth protecting? My book, my recipes, logo. Okay, so we have fast fingers. That's good. My song, my logo. So you did understand what Chinwe talked about. That's nice, my brand name. Awesome. The second warm-up question, complete the sentence, all right? If I could trademark one thing in my business today, it would be, if I could trademark. I'm saying responses before I finish my sentence. My business name, my business logo, my tagline. Awesome. Great. All right. Okay. So we get it. All right. So now the actual questions. I have 6 questions, meaning I need 6 winners. But only the winners are, you have to be the first person to give me an accurate response. Accurate is the keyword. So the first question, what is intellectual property and why is it important to businesses? Please, I hate staff, could you help me check who gives me the correct response? What is intellectual property? You have to give me like a full response. What is intellectual property and why is it important to businesses? All right. What is intellectual property and why is it important to businesses? Intellectual property to earn trust. And it's important. Simi, can you please help me in the chat? I'm trying to see who gave the correct
Yes, Beryl,
answer.
I'm there. People are answering just one part of the question and not the other.
You have to answer the whole question. It gives you competitive edge. I think Mercy Mercy Malize is the one who's responded to the whole question correctly, if I'm not wrong. It's Mercy Malize, yeah? So there, I know I saw some responses before Mercy's, but you are only responding to one part of the question. You need to respond to the whole question, right? And Mercy actually is the one who responded to the whole question. Mercy Malize, we'll just write your DM down. I'm sure we have your email address. Mercy Malize. So I will announce what the winners will get after. All right. So, but our first winner is Mercy. Now, the second question. Are we ready for the second question? Are we ready for the second question? I see people are still responding to the first question. Are you ready for the second question? Awesome. Yes. So, list 3 types of IP rights and give one example for each. Chinwe just talked about this. Remember, you have to give a full answer. List 3 types of IP rights and give one example for each. All right. You have to give an example for each, Esther. You have to give an example for each. And Faith, Abiaziem, I think is the one who's responded to the full question correctly. So I'll just write your name down, Faith Abiaziem. So our second winner is Faith, all right? Which is correct. There's trademark, copyright, patent, and she gave an example for each. So that's our second winner. Congratulations, Faith. And then our third winner, meaning we're going to the third question. Okay, ready for the third question? Now, the third question, what is the difference between copyright and trademark in terms of what they protect? What is the difference between copyright and trademark in terms of what they protect? What is the difference between copyright and trademark in terms of what they protect? Copyright original, that is Adeola Aderi. Just hold on. I'm trying to go back to Adeola's answer to see if it was the first one. Yes, correct. So, Simi, is Adeola correct? There's copyright, original works of authors,
yes,
and then trademark. So,
yeah,
Adeola, you're our third winner. Congratulations. Congratulations. So Adeola Aderi, congratulations. That's our third winner. Now 3 more questions. 3 more questions before we move on to the panel. Awesome. You guys, you're not even congratulating the winners. You have to be kind. Okay, yeah, you have to congratulate them. Okay. So now our, our fourth question. What 3 qualities must an invention have to be eligible for a patent? What 3 qualities must an invention have to be eligible for a patent? What 3 qualities must an invention have to be eligible for a patent? Sabit, I've just seen your answer and that's basically it. No, is it? Yes, new? Is it new, creative, and innovative? Simi? Simi, you're my encyclopedia.
Sorry, new, innovative, capable of industrial application is what we're looking for.
All right. So,
So, I mean, yeah, we can.
so Sabit said new, creative, and innovative. Does that count?
Also, I'm trying to look through to see if there's any other that is closer.
They actually, there is, but that's from one of the panelists. Mr. Jella, you can't win anything.
Okay, so I think we can give it to new.
Okay. So we'll give Sabit, right?
Yes, yes.
Sabit had what? Sabit had what? That's our fourth winner. I'm not moving on until I see people congratulating Sabit. All right. Are we still here? Are we following? We have 2 more questions to go. 2 more questions. All right. But you know what will happen? Okay. I think I'll take a pause with these 2 questions. Then we can have the panel, and then I'll ask my 2 final questions after the panel. I think that would work, right? All right. So the final 2 questions we'll ask after the panel discussions. So you have to stay throughout the session, all right? And wait until afterwards to be able to, see if you can get away with something. So I'll just introduce the panelists briefly. Give me a second. I want to share my screen. Yeah. Yeah. So I'll just introduce the panelists briefly and then hand over the panel session to Simi, who will be moderating. So on the list of panelists, we have, you'll forgive me for my pronunciation, okay? I'm from East Africa, so I can only pronounce East African names correctly. So Omotayomi is the head of legal at Ebony Life Group. She is joining us as one of our panelists today. And then we have Dena Wale, who's an IP specialist from the Jomo Kenyatta University of Agriculture and Technology in Kenya. And then on the call, we also have Abiola. I'm not reading the second name, I'm sorry. I'm only reading the names I'm able to pronounce. So I have Abiola on the call, who's an associate at RBMM Solicitors. And then Mr. Darren Olivia, who is a partner at Adams and Adams. And then our final panelist is Susan Musioka, who's the founder and lead counsel at Gallant Law and Associates. And then these are our panelists, so they're here to share knowledge with us around the theme for the day. And then our moderator, Simile Olua, at least I can say that. Our moderator will be Simile Olua, who is the head of legal at ImpactHER. I'm so sorry we didn't include your photo here, but yes, Simi, I think you can cover from here.
All right. Thank you very much, Beryl. I hope everybody can hear me.
Yes.
All right. Thank you. Thank you very much, Beryl. So like Beryl said, my name is Simili Olumi. I'm the head of legal at ImpactHER, and I am honored to be here moderating this session with the resource people that we have brought together to dissect the common IP pitfalls that female entrepreneurs, encounter in the course of their day-to-day activities. So, because I do not want us to take too much time, I'm going to just dive straight into the questions. So I'm going to be directing my first question to Mr. Darren. Thank you so much, first of all of our panelists for joining us today. I know that we have very busy schedules, so thank you so much for joining us. So I'm going to speak first to Mr. Darren. So in the early stages of building a business, what are the key intellectual property considerations that African female entrepreneurs particularly should prioritize? And why do you think, in your opinion, why do you think that these IP considerations are often overlooked?
Hello, everyone. It's great to be here, and thank you very much for having me. It's a very good question, and I really enjoyed the first discussion on intellectual property. For me, it's to understand how much to spend on IP. First of all, to recognize that some intellectual property you must apply for before you start. So, for example, if you've got a patent, if you've got an invention, if you go to and disclose it without getting patent protection, then you lose the ability to get patent protection. So that is the first one. So understanding that if you've got an invention, you must apply for it before you disclose it. That's the first pitfall that I see. The second one is if you do disclose it, for example, if you collaborate and you do not have a non-disclosure agreement, and you release your trade secret with the third party or you share, they can then exploit it sometimes, and I often see that happening. So you're so keen to tell people about your invention that you forget that actually by disclosing it, one, you prevent yourself from protecting it, but secondly, you allow others to then use it. So I think one is to apply for those forms of intellectual property. Then the third aspect is to try and manage, getting the intellectual property is not the end game. That is just a means to help you be successful. So you have to allocate and prioritize budget relative to what your business is, whether it's an invention or whatever your creativity or whatever it is might be. And that's when an advisor can help you. You want to go to market with, maybe you start with a bicycle and next year you get a Toyota, and the next year you get a Rolls Royce, whatever it might be. But your IP budget and strength grows with your business, and it's trying to understand how much money to put with each aspect or with each level of iteration as your business grows. So we see that quite often. And also, as I said earlier, it's very important that the main thing about business is making sure that your customers are you're keeping your customers, and you are building your business, and you're making a profit. You don't want to be spending all of that on IP protection. It's very important, but it's important to understand what is necessary and what is going to be useful down the line. So those are my initial comments. I don't know if that's really answered your question or not.
Thank you very much, Darren. I think that answers the questions very well. One key takeaway I got from there is to always register your patents first before you start, making it public, because that way you protect yourself from the patent being exploited before you even get the chance to protect it. So that is very important. Thank you very much, Darren. So my second question is going to go to Susan. So and my question is, what are the most common IP mistakes that you see among African female entrepreneurs, and how can they avoid them?
Yes, and good afternoon, and thank you also for bringing me on board. I want just to pick it up from Darren, Olivia, and I think I will itemize it into 5. One is not registering for your IP. So when you don't register for your IP, it basically leads to theft of brand name, theft of patent, inventions. And we have seen this when you have big companies that got money, they easily, they scout around and are able to pick up some of these ideas, and they put in money, and they quickly are able to, protect the invention. So by the time you realize it's too late, and you end up losing it. Secondly, the other mistake is using unlicensed products, and in particularly copyright. You want to utilize an article that is already copyrighted, and put it as pass it on as yours. And this is very common on social media and what have you. So I think that is one of the mistakes that I think amongst female entrepreneurs they find themselves into. Then the other thing would be failure to read the contracts carefully. As a young entrepreneur, or as you're trying to pursue, the steps of making more money, raising your venture, you end up meeting people who or investors who are very careful to hide their IP contracts within the clauses. So one has to be very careful, because if you fail to do that, then you end up losing your IP. And I've seen this. I think last year there is a lady who was doing a research, and had been given a lot of money, and it was involving DNA sequencing. But one of the mistakes she made was she didn't read the IP clause, which clearly stated that is being commissioned to do that work, and whatever comes out of the DNA sequencing is gonna, leave it to the investor, regardless of how novel it is, and how inventive it may be. And by the time she comes to, seek support, it was very, very late. Now, the other thing is also delay in IP protection. A number of female entrepreneurs, they miss out on seeking protection on time. And this is because maybe due to lack of awareness, you don't know that it's important that you seek protection for your invention, the creative works, and what have you. So it is usually very keen that very important that you seek IP protection at a very, very early stage. This will help you to distinguish ownership, and even as you move to seek investors, seek support, and funding, you are aware that you already have an arm with you. So I think those are the common IP mistakes that most people make. Among others is I think also the lack of awareness, and I think Darren has already touched on that. It's very, very crucial that you be aware of which IP you own, and do regular audit your IP. If you are running already an enterprise, regularly do audit, check on contract and non-disclosure agreement, so that you are able to eliminate or reduce theft of IP. And of course, in your initial business plan, while you are working on your key resource, always put key consideration on IP, so that that becomes very clear. And also the other thing which I think is actually emerging, that you need to have a policy that guides IP. If your enterprise already has employees, or you're looking into the future and you're saying in the next 5 years I'm going to have 10 employees, then make sure that at that particular point you have clearly, set out a policy that indicates who owns the IP. If I have employed someone in my enterprise, then ownership, is either for the co-owned, or is it for the creator, and that will help you a lot. Yes, thank you so much. I think that's what I have to say for now.
All right, thank you very much, Mr. Jenner. But before we proceed, I just wanted to quickly say to all of our panelists that can you please all turn on your videos so that we can see you as you speak to us. All right, Mr. Jenner, I saw Omotayomi's video earlier. So all of the panelists, please turn on your video so that we can see you. But thank you very much, Mr. Jenner. That was very, expository, and was very, very, informative. Thank you so much for that. So Susan, do you want to shed more light to that before we go and, explore the third question for the panel session?
Yes, thank you very much. I would like to add just one more. What, as entrepreneurs, we end up thinking about, what our core concern is usually financials and operations. How do we run the business? So not embedding your IP strategy can actually make you end up, chasing to protect the IP when you've already established your business. So it's really important for you to actually gel or embed your IP strategy into your business strategy. So that as a founder or an entrepreneur, as you're coming up with a vision, as you're looking at financial, projections, as you're looking at risk mitigation, you need to have that at the back of your mind, so that even as your team members are actually implementing your vision, they have that at the back of their mind, so that you're able to protect your business, so that you don't end up infringing on other people's intellectual property rights. That notwithstanding, also having
IP at the very core of your business helps in having, making sure that there's a lot of creativity and innovation within the business. So that would be the one point I would need to add, having your IP gelling or embedded in your business strategy. Thank you.
Thank you. Thank you very much. That is also very important. I mean, I feel like it's one of the things that entrepreneurs generally, not even just female entrepreneurs or African entrepreneurs now, would always overlook when it comes to, we would have our business analysis and business strategies and SWOT analysis and all of those things, and just neglect that we need to have an IP strategy as well. So thank you so much for that. So we will go to our third question now, and I'm going to be directing that at Omotayomi. So, and the reason I'm directing this to you is because, you're in the entertainment industry. So in your experience as the head of legal at Ebony Life, what are the legal risks of using online content like images, music, or videos in marketing? And is crediting the source, is that enough, to protect you from copyright or intellectual property infringement?
Okay, thank you so much, Similolua, for that question. And funny enough, I wrote about this particular question like 3 or 4 days ago, especially about credits and online content. So let me start by saying that a lot of entrepreneurs, they have the misconception that once a content is uploaded online, it means it is free for use. But unfortunately, that is very, very wrong, right? The fact that I have uploaded my film on YouTube does not mean that you can just go there, download my film, and maybe exhibit or exploit it. And I'll give you a typical example is what happened recently with Bimbo Ademoye, where she actually uploaded her film on YouTube, and TV stations in Ghana downloaded the film and started showing it on their TV. A lot of people are under the impression that once you've clicked posts, it means that automatically it is in the public and is free to use. But that's not the case. That's actually copyright infringement. The fact that the content is online does not mean that it is actually free for use. There are processes that you would take. There are processes for clearing such copyrighted work before you can actually use it. So the first question is, the fact that a content is online, maybe music, maybe artwork, maybe films, does not mean that such work is not still protected by the copyright laws. So that's one. Then 2, the fact that you give me credits does not mean that you are automatically exempted from being sued for copyright infringement. Like I said, I wrote something similar recently, and it was actually a live issue where a client called me to say, oh, Omotayo, I'm releasing my film soon, and I'm using an artist's songs as soundtrack in my film. But since I will give him credit, and my film is a form of publicity for a song, there's no need for me to seek permission, right? So I was like, hell no, that's absolutely wrong, right? So when you create a copyright protected work, there are 2 sets of rights that you have. The first one is your moral rights, and the second one is your economic rights. And just like the first speaker had, spoken about, these 2 rights are actually rights that are together. It is not either. They are actually together. So one is actually dragging the other at the back, meaning they are together. You can't decide to, oh, let me give him credit. Oh, let me just pay him and not give him credit. No, these 2 rights are together. And anybody that owns a copyright protected work actually owns both rights, meaning you need to give the person credit, one, and you must also pay the person. So you can't sit at the comfort of your room and then determine that, no, you don't deserve to be paid. I would only give you credit. So except the copyright owner has given you an explicit permission to use such copyrighted work without payment. That's the only ground upon which you can actually proceed to use such work without payment. But then there are other exceptions, like maybe fair use, right? Where you can use some work under some form of exception for you to be able to use it without necessarily seeking for permission or even giving credit at times, right? So I think that's actually the issue in this case. Thank you.
Thank you so much. I really, really love that. It was very explicit. And the thing about people thinking once I just give credit to the owner, I have done what I need to do. But there's also the place of getting the permission and clearance first. And even if there's need for royalty to be paid to the person before you are able to use it. Thank you very much for that. And I love the note that you ended, because it leads me directly to my next question, which I'm going to be directing to Susan. And it's talking about, can you break down, Susan, I want you to help us break down the concept of fair use and what the common misunderstanding is, and what the common misunderstandings that could lead to copyright infringements. So what is fair use, and what would you have to do where you are now crossing the line and it's no longer fair use?
Thank you very much. I'll go ahead and answer the question. So what is fair use? So fair use is a concept that was brought up in order to balance the rights of a copyright holder with public interest. Like the previous speaker has said, the copyright holder has two rights. There are moral rights and there are economic rights. So how do we balance the copywriters' rights, copyright holders' rights, and public rights in accessing and building upon creative works? So some of the purposes where the public can use, can qualify, can use fair use to qualify where they're using their work is, for example, when there is commentary or criticism. So, like news analysis and reviews of, particular works, or when it comes to satire, when it comes to plays and all that. So where there's parody and satire, or when it comes to news reporting, because it would not be in public interest for a newscaster or a broadcaster to be paying, say, for example, a copyright holder certain royalties to just report news, because it's in the public interest for the public to actually know what is going on. And the other reason, or the other common purpose that may qualify as fair use, is when it comes to teaching or research, scholarship, teaching, and research. But there are some factors that we need to have in mind before we start, using fair, the term fair use to qualify using copyrighted work. So what is the purpose of this use? Are we using the copyrighted work for commercial, or is it for non-profit or educational reasons or purposes? So what is the purpose and the character of use, right? So another thing that maybe the court will look at or determine whether the work has, there's fair use is when, what is the nature of the copyrighted work? So is it, so the nature of the copyrighted work, it could be the original work, is it more factual or is it creative? So when you're looking at factual works, you can actually rely on fair use, because, a fact is, for example, Mount Kilimanjaro is the tallest mountain in Africa, and it is in Tanzania. So that's factual. But if you use that fact together with highly creative works, but then you copy most of the creative aspect of the work, then you cannot use, that defense of fair use. So that's the second factor that a court may look at. The other one would be, so the original, if you look at an original work, but then you copy most or the substantial portion of the work, or the heart of the work, then you cannot rely on the sense of fair use. So, so the court will also look at how much or how substantially have you use the copyrighted work. And then of course, now the last would be the effect on the market for the original work. So if you copy most of the original work and rely on fair use as your defense, but then you harm the market or potential market of the original work, then that defense will actually fail. So as the previous speaker has said, when it comes to crediting the source, that people may think that that will suffice, but it's not. It does not suffice. It is not enough when it comes to copyrighted work. Thank you. Back to you.
All right, thank you very much, Susan, and thank you for that. Because one thing I took away from that, first of all, is that once you're getting economic gain from it, you cannot claim fair use, first of all. And then the way that you're using it is also very important. Is it for educational purposes? And the amount, of what you're using from the person's intellectual property as well. Those are the things that you'd look out for. So there's something, particularly I learned this from secondary school, and Matia would say mindless lifting. When you just lift somebody's work mindlessly, no corrections, no extra research of your own. That, of course, is not you fairly using somebody else's intellectual property. So thank you very much, Susan, for that. So I'm going to be speaking directly to Biola now, Abiola Olanrewaju. So based on your experience in the entertainment industry and also fashion law, that's why I'm directing this question to you. So I wanted to ask, how can entrepreneurs draw inspiration from others' works without crossing into copyright design or design infringement?
Hi, everyone. So thank you very
Bella.
much for this opportunity. Yes, thank you very much. Can you hear me?
Yes, I can. Yes, I can hear you, Bella.
Okay, all right. Yes, so I would say, all right. So I would say that getting inspiration from people's work or probably design, any copyrighted work is very normal. We can get inspiration from, even just looking at a plant or probably observing a color pattern. You can get inspiration from anywhere. But however, when it comes to people's intellectual property, it is imperative that creative or entrepreneurs in this case, are being ethical and are actually getting, also direct copying it and lifting whatever it is you're saying. So let's say, for instance, there is this what's it called on Instagram, Imadusu, and once you see their skirts, once they use there's this sequence they use on the skirt. Oh, so sorry. I think that must have been my internet. So can anyone hear me?
Yes, you're back. Thank you.
Okay, yeah. So once you see their design, once you see their product, this belongs to Imado. So however, where you are a fashion designer and you love the idea, you love the way they put their colors together, which is beautiful. It's an idea. Like the idea of colors, it's an idea, but you lifting it the same way and, just incorporating it into your own brand or your production, then we have an infringement, most likely a design infringement. So I would say that expressions, ideas are free. You can get ideas anywhere. We have ideas of, love story. We have ideas of looking beautiful and expensive, but where their expression of it, documented expression of its palpable expressions of these ideas, then those are protected by the laws, and you must tread carefully when you are trying to draw inspiration from these ideas. So I would say that one, it is imperative that you, when starting your business, be it fashion, be it, content creation or writing, whatever you may want to, delve into, it is important that you conduct an extensive research. Make sure that whatever you are drawing inspiration from, be sure that you are not copying another person's work. You might think, oh, I saw this thing and I'm just drawing inspiration from it. So by the time you start, putting everything together, you might end up copying something from that brand. So ensure that you conduct an extensive research. And also, I would advise that in the process of you, trying to create your own product or your content, it is imperative that you document these things, because that way it gives you this there's this thing that comes with people writing, picking up a pen and just noting these things down, sketching. There's a way you just get into the creative mode where you can, correct some things. Ideas come that way. Document your process. So, God forbid, in case you have any legal action, it is evident that you've been documenting these things, and it won't just seem as though you lifted these things. So I would also say that when you are not sure as to how to go about these things, people often shy away from getting lawyers. You can always consult a lawyer. You can always speak with a lawyer. A lawyer can always guide you. The lawyers are there to help you and to help you avoid, any legal issue and any future problem. And another thing I would also say, I usually tell people, especially individuals that come to me who want to start a business, is that whenever you're starting a business, have it at the back of your mind that you are not restricting yourself to Africa, be it if you're from Kenya, Nigeria, Ghana, Sierra Leone. Have a picture that you want your brand to be global. So by the time you are going global and the things you are creating is similar to a designer outside the shores of your country, then you would have problems. So be futuristic in your creation. You don't limit yourself. Look at the bigger picture. Do not mistake, because opportunities can come from anywhere. You can derive inspiration from a designer in Italy, India, Japan, or China. But in all of this, ensure that a part of you, your own originality, your print is on your design, that you can categorically look at this design and say that I bettered this. Not that I just saw somebody, I just lifted it. So you can derive inspiration from colors, from schemes, from mood, and then you can derive inspiration from customers' feedback. You may come across it and you understand how a customer feels by using a particular brand and how it's made them feel. So that alone, that is a concept. That's an idea that, okay, this product is actually catering to the needs of these people, is making them feel confident in what they wear, irrespective of their body type or their body shape. So that alone you can have that idea that I want to make sure, I just want to ensure that my customers feel good in whatever it is they are wearing. So you having that at the back of your mind, then you can just go back to the drawing board and come up with something beautiful. Thank you.
All right, thank you very much, Abiola, for that. I really like what you said about drawing inspiration from different type of things, but also putting your own spin into it, right? And also design somebody else's concept. The beautiful thing about creativity is that there's a lot to go around. So it's okay to draw inspiration from something, but put your own spin into it to make it uniquely yours. So that's what makes it uniquely yours. So thank you very much for that, Biola. So I'm just going to, while you're here, also go ahead and ask you this. And I wanted to just ask you if there are any reliable sources that you know of for royalty-free content, and what should entrepreneurs look out for when they are using them? Because we know that we're in the era of social media content, and entrepreneurs are doing a lot of content for their business. So are there any sources for royalty-free content that they can use for their businesses?
Yes, yes, there are a lot of platforms or websites that you can, get royalty-free content from. So, for instance, you can. Okay, so let me just list the few that I was able to, lay my hands on, and I know that people have used in the past. So, I know people are popular with Canva. You can get images from Canva. However, there are ones that that you have to pay for, and you should pay for that. So for images, you can get on Canva. Even for audio, there are YouTube audio. There are some sounds, there are some songs that are free, royalty free, that you can use. However, I would say that what you should look out for, and I will also ensure that I would crave people's indulgence, that we should always try to kind of read the terms and conditions, because the moment people see terms and conditions, they just agree, they just move to the next, they just move to the next thing on their screen. So it is important that there are some royalty free content that would require you to credit the authors. Like, it will just require you to credit them, while some would not even permit you to use it for any commercial purposes. So it is imperative for you to read through the terms and conditions. And if you don't even have the ample time, get a lawyer. Just dump the old burden of reading and skimming through all of this thing. Just dump it on the lawyer. They go through it for you, and then they advise you accordingly. Because at the end of the day, your lawyers are there to protect your interests and to ensure that you are, compliant to the law. You are not infringing on anyone's rights. Because once your lawyer, notices that someone is infringing on your rights, they will go for the person. So the onus is also on you as an entrepreneur to ensure that whatever you are trying to do, whatever product you're trying to use, content you're trying to use online, you are not using it in a way that would infringe on the creator's rights. So go through the terms and conditions. There are a lot. There's Pixar Baby, there's Pixel, I believe, and there's Unsplash for images. There are a whole lot of websites like that where you can get royalty-free content from, and you can use them to promote your business. But it is important to ensure that you are not infringing on their rights, and you're also, you've gone through the terms and condition and giving credit to whom credit is due. Thank you.
All right, thank you. Thank you very much, Abiola, for that. So I just also want to throw the question open to the rest of the panelists to see if there are other sources of royalty-free content that women can benefit from, that they can use, and while they're, doing their content or for whatever they're doing for their businesses. So I'm going to ask Omotayo if there are any other resources that you want to share with us.
Yeah, I think she mentioned the common ones already, like the Pixel, the Unsplash, and all that. And like she rightly said, right, it is very important for you to read the terms and conditions, because there are some instances where they may say, oh, this is royalty free. But if you use a number of them, they might say at this point, you have to make payments. Or if you are using it for a commercial film, right, they might say, oh, you need to pay because you are going to exploit all these materials, right? So it is very important for you to read the terms and conditions before use, right? So that's the only thing I had to add.
All right, thank you. Thank you very much. So I'm also going to just ask Darren, and then we'll go to the next question. Darren, do you have anything to add to this?
I do and I don't. I used to run a blog. I do run a blog called ImpactHER.
Sorry, Darren, you're muted.
Someone is muted.
You're muted again. Okay.
Am I still muted? I think people are trying to stop me from talking, which is fine. I used to run a blog. Well, I run a blog called ImpactHER, and one can use, it relates to one of the questions in the panel here, one can often use copyright material for the purpose of education, right? Provided it is used in a way, even material that one would ordinarily have to pay for, if you're using it in a way which is purely educational, and it's what we call fair dealing or fair use. So there are times that even copyrighted material that you'd ordinarily have to pay for. So, for example, if I put up a picture of, let's say, Messi on that's taken, and I put it up for purposes of illustration on this panel, I wouldn't be at fault because I'm educating and it's purely for that. But if you're in the context of your business, then of course you're quite right. You have to try and get copyright-free materials. There are, on a Google search, apart from the resources that have just been mentioned, on a Google search, sometimes I will say if you go to an image search, it will actually classify which images are free for use. But then you must go in and just check the previous speaker said this, just check the terms and conditions of that use before you use it. But that's the only thing I can really add to that conversation. I think it's been fairly comprehensively answered.
All right, thank you. Thank you very much, Darren. So I'm going to speak directly to Jenna. And I was going to ask you, what steps should an entrepreneur take if they've already used third-party content without realizing the IP implications? So what steps can they take when they've already, had an IP infringement? Jenna, please go ahead. Thank you.
Much. I think the first thing is that you, as an entrepreneur, you remove the content immediately. This will prevent further infringement. Remember, one thing about IP is up to the owner to, push for litigation. Eh? So if you are lucky that the owner of the IP is not aware that you are using a content that is already protected, then you may be lucky. Then I think now, to move on and even to safeguard yourself, the other thing is that you have to check the source license and get to know if that license gives you the rights. If you're not using it, as Darren has put it, if you're not using it for education purposes or private use, then be very careful and you have to really check on the source of that license. Then you can always contact the right holders and apologize and request for permission to use the license, and then keep records of communication. And I think the other thing is that you can always review all the past content. So I think the most important thing is that before you use any content, be it online and or whichever media or platform you're using, then always get to understand the terms and conditions so that you don't get yourself unawares. Otherwise, you may be penalized. And sometimes as a young entrepreneur, as you're growing, if the courts come for you and you're not able to meet that cost, then it simply means that your business is gonna die. So you have to really check on the terms of references and just have a look at if the license is open, if it's free for use, and always have also a legal expert each and every time, especially if you're going to use an article commercially for commercial purposes, and at that particular point you don't know whether that is a protected IP or not. So you can always consult your legal team and IP expert so that you can get a clear view on whether to use it or not. I think that would be my submission for now. Thank you.
All right, thank you very much, Jenna. Thank you. Says that the first step is to, once you realize there's an infringement, the first step is to take it down, right? Very important. Also, one thing that panelists have been saying is to do your proper research. Don't just pick up some from somewhere because it's a trending bit and just use it without knowing, how to properly get the permission to use the song or the content, right? So it's very, very important. And then another thing that has been recurring is making sure that you read terms and conditions. A lot of us like to skip it because we're like, oh, it's too long and I can't take my time to read all of these things. But it's very important, particularly for businesses, when you're using contents, to read the terms and conditions and be sure that you're not infringing on anybody's intellectual property rights, right? Because as much as we want to protect our own intellectual property rights, we also want to ensure that we're not infringing on other people's own, because it's going to be expensive for you when they come to you to say that, okay, you've infringed and this is the consequence, just as much as you also don't want anybody to infringe on your own intellectual property. So I'm going to be directing my next question to Omotayo. And the question is, when you're outsourcing to content creators, rather, like when you're outsourcing to videographers or designers, who owns the intellectual property? And how can entrepreneurs ensure that they retain the rights? I know that we had mentioned it in passing while we were having the keynote, but I also just want you to, expatiate on it, on who owns the intellectual property and how do entrepreneurs ensure that they retain the rights.
Okay, thank you for that question. I would say when it comes to creative works, right, the first owner is actually the author of the work. So, but then it depends. If you as an entrepreneur, you have an in-house content creator, that is someone in maybe the social media department or the content department, right, that creates content for you, do your graphics designs and everything, and you have a contract with the person is your proper employee, right? It means that all the creative work that the person creates during the course of the person's employment with you automatically belongs to you as the employer, because you employed the person and the person is working based on your instructions. And of course, your contract too, your employment contract too, should specifically state that all the creative work the person would create under your employment automatically belongs to you. So that's scenario one. But the other scenario is if you have commissioned a third party that is not your employee to work for you, maybe freelancers, maybe influencers, right? You commission them to say, oh, create this video content for me, create this graphics design for me. In that case, sorry, can you hear me?
Yes, I can hear you now.
Can you?
Yes, we can hear you now. You can go ahead.
So if you are commissioning a third party to create a creative work for you, then in that case, the author would actually own the copyright. Sorry for the interruptions, please. So in that case, the author would actually own the copyright in the created work, being that under the Copyright Act, the person that creates the work owns the work. But what you then have to do as the entrepreneur that has commissioned someone else to do the work is actually to, number one, define all the terms of the commissioning, in the sense that, to be clear, number one, regarding what the person is doing, the fees and everything, right? And the fact that in the intellectual property in the creative work actually belongs to you. So, and the best way to do that is by signing a contract. So you need to sign a contract with the third party doing the work, specifically stating that all the intellectual property in the work the person would create would be treated as a commissioned work that is actually owned by you. And you also need to make the person understand, because sometimes they will say, oh, you never told me that you would own the copyrights in the work, yada, 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 I would have charged you more and all that, right? So you need to be crystal clear when negotiating to state that, oh, once you've created this work, it means that I automatically own the copyright in the work. And don't end it there. Also, take further steps, right, to actually register such copyrighted work. For example, if you are a filmmaker and you have commissioned producers to make films for you, for example, you see a lot of YouTube content nowadays, a lot of films on YouTube. Most times people just commission producers to make these films, right? And they then pass the intellectual property in the film to the person that have commissioned them to make the film. So if that is the case, ensure that you have your contract in place that specifies the relationship between you and the person that created the film, that specifies the fact that you own the intellectual property, but then take further steps to protect the work by maybe registering it with the Copyright Commission, and also taking steps to actually maybe trademark the title of the film, trademark the important characters that you have, and ensure that you have proper documentation that indicates that you have intellectual property in such created work.
All right, thank you very much, Amatayami, for that. That was very, very explanatory. So I'll just go to the next question so that we do not take too much time. I see that our time is very fast spent. So my next question is for Susan Musioka. So what intellectual property considerations should be kept in mind when encouraging user-generated content like customer photos or reviews? What are the intellectual property considerations that entrepreneurs should keep in mind? Susan, please, you have the floor.
Thank you very, very much. So we've seen businesses actually using user-generated content where they're trying to either, try and expand their brand identity or actually show community support and, maybe even part of their CSR. So, so the user-generated content is, say, for example, customer photos or reviews or videos that have been generated by the users themselves, so by customers themselves. So as an entrepreneur, as you must be very careful when you're looking or you're considering on using this kind of content. So firstly, you need to obtain clear permission or license from the users. So it's not automatic because a customer or your clients actually posted something on your social media and they use their own image. It's not automatic that now as an entrepreneur you have rights to use the photo or video to use commercially. So because that user is the original creator and there are copyrights that accrue to it. So it's not automatic. So it's good practice to actually get permission or to actually have a license granted. And this must be very explicit permission. Preferably, it must be written. It's always good to have a written permission. And the permission, you must keep it. You must keep it for your record, obviously, should a dispute arise in the future. So this permission must be very specific. So you, as an entrepreneur, you need to be clear on the scope of use. So, so the permission, are you allowed to use it on all social media platforms, for example? For how long do you have this permission? Is it permission for a year? What's the term of use? And say, for example, geographical territory. Are you just required to use it in your marketing campaigns in Africa or in a certain jurisdiction, right? So the other aspect I think entrepreneurs need to have in mind, other than getting permission or license, I think it's important to be clear and to respect the rights of the users. So you need to be able to have obtained consent to use either their likeness and not to border on infringing on privacy, or with data protection actually being a major concern or for businesses and data subjects. I think it's actually very important to have that in mind. As a business, as an entrepreneur, it's very important to ensure that you establish moderation policies so that you're able to confirm that this user-generated content is actually not an infringement on another IP right? So you don't want to be using content that is already in the first instance an infringement. So once you are able to moderate and actually just monitor whether there's any infringement, then you'll be able to see, are you able to use it? Do you have the permission to do it? Do you have the license to do it? Or if it actually infringes on another person's right, on an IP right, then you promptly just you take it down. Another aspect is ensuring that you implement clear terms and guidelines. So you give the users who are generating the content clear terms and conditions, outlining what type of content is acceptable, right? So it could be, you don't want content that is bordering on being offensive, for example. And of course, you don't want content that is copyright infringing on other rights. So it's very important for entrepreneurs to actually set the threshold to their users who are generating this content, that, hey, this is what is acceptable, and these are our guidelines, and this is what you need to abide by. Thank you very much. Back to you.
Thank you very much, Susan, for that. Thank you. So I'm going to go straight to our final question, and that is for Darren. So for entrepreneurs reaching global markets, how do IP laws vary internationally, and what should they be mindful of when they're protecting their brands abroad?
Very, very good question. First of all, just to understand that the nature of IP is firstly a territorial concept. So I've been busy in the chat. If it's okay for use in Nigeria, it may not be okay for use in Kenya. It may not be okay for use in Europe. So one has to spend the time going to each territory and clearing and registering the trademark. But of course, that comes with a cost. So it's very important then to rank the countries which are likely to be markets of yours very carefully. Or so is to identify those countries, either that they're going to be big markets for you, or if you know that there's a competitor there and you want to block them, and you, it may not be a big market, but you may strategically want to protect your brand or your patent or whatever it might be there. So that's one of the things internationally. The nice thing about that's for trademarks, and to some extent patents as well. The nice thing about it is for copyright is that it exists in most places automatically in most countries because of what we call the Berne Convention, which a lot of countries have signed up to, which allows you to protect your copyright works automatically in other countries which have signed up to the Berne Convention as if that copyrighted work had been created there. So there is an element of copyright. That's the nice thing about copyright, where you get a form of free protection overseas, and that's useful to know, especially, for example, for a logo of your trademark. But yes, generally speaking, is to realize that one needs to go and find out about the intellectual property laws in each country to make sure that your mark or your IP is protectable there, or you're not infringing someone else's rights. That's also the important thing. Two is to try and match your budget with your hopes and expectations for that particular market. And there are many countries in Africa where the governments give a grant funding towards IP protection in export markets, because of course that helps the government create wealth and grow employment locally. So look out for the funding for that. I know that there's something like that in South Africa. And then the third thing is to realize that I think it lays on from the second point. You can't conquer the world, even though you would like to. So you can't be Mr. Donald Trump and pretend you have rights everywhere. You have to go strategically into each country, and I think that would be my take-home points on international protection for those rights. The one thing I would just say, where it is most expensive, tends to be, it's all relative to what you're earning and what you're creating, but is in the patent system. So there's strategic use of how you get funding for patents, using patents yourself. So let's say, for example, you've got an idea that has potential everywhere. You can, through a system called the Provisional Patent System and through the PCT, Patent Cooperation Treaty, give yourself time by cost effectively protecting your patent locally by filing a provisional patent, allowing you time to refine your technology, but also seek funders and partners to help you not only enhance your innovation externally, but also file those very valuable patents in those other countries, which tend to be more expensive, much more expensive than, for example, a trademark. But those are my closing thoughts. Thank you very much.
Thank you very much, Darren, for that. I really appreciate that one of my key takeaways also from that is that you need to do your research and you need to have some sort of scale of preference as to which countries you want to have your, intellectual property patented or copyrighted or trademarked in, just so that you're very strategic about how you're doing that. So thank you very much for that. And again, thank you very much, Darren. I see that you've been answering questions in the question and answer session. So thank you very much for that. That reduces the time that we need to spend in taking questions. So thank you. And this brings us to the end of the panel session. A huge thank you.
Can I just say one thing?
Yes, please.
I
Go ahead.
I hope I didn't stand on anyone's toes by answering the questions, but the
Oh, no,
conversation
no.
was going so nicely here that I thought that we could talk for 3 days, I think.
Yes, I mean it's amazing. Thank you very much. I really appreciate that because, I mean, our time is fast spent. It was supposed to be 2 hours. We've used 2 hours, so answering the questions really like cut down the time that we need to spend answering the questions again. So thank you. You did great. Fantastic. Thank you very much. And thank you everyone for taking time out of your busy schedule. Like I said earlier, I mean, lawyers are very busy people. So thank you so much for taking time out to be here and sharing with us your wealth of knowledge. I mean, a lot of gems have been dropped here. And this is, like Beryl mentioned earlier, this is something that you would have to pay a lot for. This is something that you'd have to pay consultation for you to even have an idea what you need to do. And you are getting these things for free. So thank you so much for coming and thank you so much for giving us this invaluable, insights to how to protect our intellectual properties and the common pitfalls that, female entrepreneurs need to avoid. So I'm going to see if there are any more questions that we need to answer, and then I would defer to Burial. No, I think. Okay. So someone is saying, can we have a copy of the notes? I'm sure that the communications team would communicate with us. The slide should be made available, but the communications team would communicate that with us. Is there any platform, any Telegram or WhatsApp platform? Okay, yes, definitely. Communications, please respond to that. We have a Telegram group for our community members. Okay. So all of the questions have been answered. Thank you. Thank you very much, Darren. All right, so I'm just going to defer to Beryl so she can continue. Thank you so much, my amazing panelists. It was fun doing this with you. It was insightful doing this with you as well. Thank you so much.
Thank you, Simisolewa. Thank you.
All right, let me just stop sharing my screen. Thank you, Simi, Darren, Omotayo, Susan, and Jenna. You're really, you've done the topic justice, right? And we really appreciate. All right. So I think I was also looking at the Q&A section, and I saw that most of the questions were covered. So I'll just go ahead and ask my 2 remaining questions. But this time I'm taking into consideration that Faith, maybe just type your question again in the Q&A section, then it will be answered. It's Faith, yeah? Right. Just type your question in the Q&A section and then it will be answered. All right. So like I said, we have 2 questions remaining. And then this time I'm going to give consideration to the French-speaking people. So I will be getting answers or choosing my winners from the French speakers. We already have 4 speakers who are English speaking. So we have to be fair, okay? Now, just so that we don't miss your questions, please make sure that you drop them in the Q&A section. All right, just to make sure that we don't miss your questions. Let me go back to my questions now. Okay, are we ready for the French speakers? Are we ready? Question number 5 and 6, this goes out to you. Question number 5 and 6 goes out to you. Please let me know in the chat section if you're ready. I don't speak French, but I'm sure I'll figure out whatever you're saying. Yeah, I knew it. I'd figure it out. All right. Where is it? Okay. All right. So my fifth question, and this is also from what has been discussed just now. All right. My fifth question, what are two internal strategies businesses can use to protect their IP? What are two internal strategies businesses can use to protect their IP? You can just drop your responses in French. We have Judith, who is a French lead, and she knows the responses. She knows the correct answer. So she'll pick out for me who drops the correct response. All right, I'll repeat the question again. All right. What are two internal strategies businesses can use to protect their IP? What are two internal strategies businesses can use to protect their IP? Then Judith, you can just let me know in the chat section who has dropped the correct response. It's for the French speakers, guys. Great, I see you. You've been very consistent in the chat section. Really, really, I mean, I've noticed your engagement. Well done. Judith, we only have one response from the French speakers. I'll give 5 seconds, 5 more seconds. 5 more seconds. To see who drops the correct response. Strategy 1, strategy 2. I think that's the only thing I can read. Judith, is Mommy's answer correct? Or Abdul's? Just type it out for me in the chat so that I can know who is. Judith? Or, okay, there's employment education. That's an English response. Judith, from the responses that have been dropped, who has dropped the correct response, please? Just let me know. All right, so I'll move on to the next question as I wait for Judith's response so that we don't spend so much time. Now, the next question is the last question, basically, right? Give an example of a hidden IP asset a small business might overlook. Give an example of a hidden IP asset a small business might overlook. Give an example of a hidden IP asset a small business might overlook. Someone is saying secret entertainment, song infringement, okay. What else, what else? Through an IP audit. I'm giving, okay, the clue is you can actually get that through an IP audit. Why are people saying secret? Give an example of a hidden IP asset a small business might overlook. All right. Okay, and I think since I'm not getting response from Judith, I think the first person who gave the correct answer here is design. The one who wrote designs, Loretta. That's Loretta. So that's our 6th winner. Loretta is our 6th winner, right? Or basically the 5th, all right? And Mami, yes. I'll pick Mami Meta as the final winner. So we have 6 winners. There's Masi Malize, Faith Abiazem, Adeola, Adeyeri, Sabit Hadwat, Loretta, and Mami Meta. So for our 6 winners, you'll get emails from the ImpactHER team. 3 of you will get free websites. These are professionally developed websites for your businesses. And then 3 of you will get a free contract. What do we call them, Simi?
So Barry, what we're giving them is non-disclosure agreements. To be drafting free non-disclosure agreements for them.
All right, awesome. So 3 of you will get free services on NDA drafting, and then 3 of you will get free websites. Whoever it is, I cannot tell, but you will get emails confirming that. So thank you so much for that, and thank you so much for your time.
Sorry for cutting you. So also the 6 winners also will all be getting an IP audit checklist.
Awesome.
So they will also be getting an audit checklist from ImpactHER. Thank you.
All right, that's good. So Sabit, if you already have a website, you can get the other option. All right. So that's actually good. So we can balance it out. Thank you so much, Simi, for that. And for everyone who took time to join. At this point, I'm going to hand over the mic, especially again, to Favor, so that she can give closing remarks as we wind up the day and the week, basically. So Favor, over to you. You'll introduce yourself. So just share my screen so that you can exactly know who she is. That's it. Thank you. Favor?
Okay, hi there. Thank you. Okay, so this is funny. Okay. So I was saying this is funny because I'm wearing black hair and I'm also wearing black. I guess I'm just realizing that I really do love black. I want to say a very big thank you to everyone for joining this session today. But just before we conclude, please can we get like all the panelists? Oh, Madam Owa is here. Thank you so much for joining. She's supposed to be our keynote Sinwe because she's currently in Geneva for the WIPO summit. So please, could you just give us like maybe a 2 minutes address as we just quickly wind down, ma'am?
Can you hear me? Good afternoon, everybody.
Yes, I can hear you now, ma'am.
Okay. Oh my gosh. Yeah, I'm just trying to. My apologies. Can you still hear me, everyone?
Yes, we can still hear you.
Okay. My sincere apologies. I have just settled down. I was traveling, so I couldn't take the keynote address, but I believe the message was appropriate, delivered by my partner, Chinwe, is appropriate. I want to thank ImpactHER for the opportunity. And I also, I missed practically the session, but I hope it was impactful. I also want to express my willingness and availability to support the women entrepreneurs, to support ImpactHER, not just as an individual, but also from as an organization. So thank you so much. Well done to everyone. Well done to all the women making and creating waves. Well done to ImpactHER. Very proud of you. Thank you very much and have a wonderful day. Bye.
Okay, thank you very much, Ma. And so we'll just quickly take a picture. So please can all the panelists turn on their cameras so we can just take a screenshot. Thank you.
Darren.
Okay, so just waiting for everyone.
Darren, know you?
I am here. Is it work? Gee.
It's Uwa.
Yeah. Nice to see you. We missed you.
Traveling, running all over the globe.
Your colleague did well.
Okay, so
As expected.
have we taken the pictures, please? Hi, Grace. Please confirm if we're taking the picture. Okay, we have. Thank you so much, everyone. We can just turn off our cameras. Thank you. Okay, so I want to say a big thank you to everyone for joining us today for our weekly webinar. And we had people join us here on Zoom and also on YouTube. It's been truly an insightful session, and we are grateful to our esteemed speakers for sharing their expertise and perspectives. Your contributions have deeply helped our understanding of intellectual property, and we hope that everyone leaves with valuable takeaways. And to all our participants, thank you so much for joining us, for your engagement, your thoughtful questions, your presence. And then we encourage you to continue the conversation of intellectual property, apply the knowledge that you've gained, and stay connected to us for future program and resources. And also, we had a lot of questions. This session would be available on YouTube for us to watch. We know that during the course of the program, due to like the network issues, some people had to drop in and out, but it will be available on YouTube for everyone. And on behalf of ImpactHER, I want to say thank you and wish you continued success in your work. I look forward to welcoming you to the next session. Thank you once again, and do enjoy the rest of your day. Thank you, everyone. Bye.
Bye, everybody. Bye.
Cheers.